I requested to move. I'm going to move to that side because I need a problem.
Okay.
Yeah, they wanted me to put this thing, but it's never aesthetically. It's not going to be appealing.
Okay.
It will be like what inside windows in that.
Dlamini says, put this thing on his back,
Yeah.
putting it on yours.
Sure.
And how did it go?
Yeah, we spoke to her. And then
That's interesting.
yeah, this one is not this and nice because you guys pay me something else.
No, she wasn't expecting. Yes, I think she was probably just expecting to say no. Shucks.
So he considered that 50-50 now. Said it can go either way.
Mm.
And remember, we are moving her from Syria to there because she we moved from high deficit.
Yes, yeah. Can she push here maybe for tomorrow?
As soon as a week.
Really?
Maybe Friday.
I hope it's not to go and get instructions from
That's the thing.
What do you think?
That's my one.
What you should do on the weekend? What was you doing on the weekend?
And she has the kids as well. She has the
As please the court, Your Worship, the 4th day of September 2023, State Court Case number 20A113/2023 is the matter against Nandipha Magudumana, presiding judicial officer, Ms. Delaja, appearing for the state as Matuku, the court interpreter, Mr. Makala, and the defense is Mr. Machini Mutou. The court shall recall that Advocate Frans Dlamini place it on record that he is not available today, but that Mr. Mutou will be taking over. Your Worship, we adjourned at the stage where the defense was busy addressing you. I want to request that Mr. Mutou first confirm his appearance, and just after that and before he proceed with his address, the state would want to address the court on one aspect as a president.
As please the court, Your Worship, I confirm that I appear on behalf of the applicant in this matter. Your Worship, I also confirm the arrangements in as far as taking over further submissions to this court is concerned, that I will be addressing the court on some of the aspects emanating from the heads that were submitted to you as a court basis.
Thank you.
Just before then, I wish to confirm that as per my undertaking, I made an undertaking to provide the defense with my heads by the 1st of September. But I wish to confirm that immediately when we adjourn on the 30th of August, I delivered a copy of my address to Mr. Mutou. And I also wish to say, in my absence, I also requested my colleague, Mr. Letaba, to deliver same to the magistrate in chambers. And that was done on the 31st of August, according to my information. If Mr. Mutou can confirm receipt.
May it please the court, Your Worship, I acknowledge receipt of the submissions by the state as alluded. Your Worship, similarly, I would also like to confirm adherence to the directive of this court in as far as submission of or delivery of the heads is concerned. Same was indeed delivered to the state on Friday the 1st of September as the court pleases.
So confirmed.
Thank you. I also confirm that I received in chambers a copy of the state's address in opposing the application. It was delivered to my office. Thank you very much.
As it pleases.
As the court pleases.
There's an aspect that I canvassed with my learned friend just before we started. The court shall note that in the beginning of these proceedings, both the state and the defense agreed in terms of the applicable schedule. That was Schedule 5. And the matter has since proceeded in terms of that agreement. But the court shall note that only during his address, Mr. Dlamini placed an issue on the aspect of a schedule. And he gave reasons for that. I have since obtained a written confirmation in terms of Section 60, 11 capital letter A of the Criminal Procedure Act 51 of 1977, a copy of which was hand-delivered to Mr. Mutou, wherein the DPP, in terms of that section, confirmed that this is indeed Schedule 5. I wish to hand this over to the court, and if no objection from the defense.
Mr. Mutou?
As it please the court, Your Worship, I confirm that I received this notice from the Director of Public Prosecutions, Free State, in as far as the schedule of this offence is concerned. Your Worship, receipt of this or acknowledgement of delivery of this notice should not in any way, shape or form be misconstrued to be a concession on the part of the defense in as far as the argument is concerned relating to the schedule. Your Worship, I would not take this further and I would address it sufficiently when I have the opportunity to do so at a later stage as a court pleases.
Thank you. The written confirmation in terms of section 60, subsection 11 capital A, subsection A of the Criminal Procedure Act is received, and it is marked as exhibit
In terms of my records, the last exhibit was H. Is the written submission by the applicant. No, it was the affidavit. H. Then there was
exhibit J was also received an exhibit. Let me just go back to the exhibit itself just to make sure.
I think the written address by my learned friend was exhibit I.
And then J.
J.
Right, let's mark this exhibit K.
As it please the court.
As it please the court, Your Worship.
Yes, sir.
Can I just indicate what is written on this confirmation? It was issued by Advocate Nabila Sumaro, the Director of Public Prosecutions,
That's correct.
indicating and confirming that the applicant before court, Ms. Magudumana, and 11 others, will be arraigned on inter alia 4 counts of contravening Section 3 of the Corruption Act, and that for the purposes of bail proceedings, corruption falls under Schedule 5 of the Criminal Procedure Act as it involves more than 500,000, or it involves amounts of more than 100,000 if it's alleged that the offence was committed by a person or a group of persons or syndicate acting in the execution of furtherance of common purpose or conspiracy. So that this is what is contained in a summary of what is contained in this document. I haven't read out the full document, just for your information.
Yes. Can I, with the permission of the court, can I ask that we swap seats with Mr. Mutloum? He indicated that he would need a podium, and we went around the whole building to try and get him a podium. Unfortunately, they are all fastened like this, they can't move. So for his address, can I allow him then to address you from here?
Yes, you
As
may.
a president.
Thank you, ma'am. Mr. Mutloum, I'm sitting slightly with my back towards you, and it's not out of disrespect or anything. I'm just trying to work on my laptop, and I've got some of these microphones in my space.
That's
So please excuse me for doing that.
That's understandable, Your Worship. I must also indicate that it feels a bit awkward that I'm standing on the other side of the fence. I hope this would not really go down to even impact on my address, but I still appear on behalf of the applicant, Your Worship.
Thank you.
Your Worship, I think what one is required to do in this bail application, take into account that this is a continuation from the address that was presented by Advocate Dlamini on the 30th of August 2023. In avoidance of regurgitation of some of the aspects which were eloquently articulated and dealt with by my learned colleague, one would just to have a structure and framework of my address, point out salient issues emanating from this address of my learned colleague. Your Worship, you would note that our address commenced with the preliminary issues. Now, I intend to address the court under the following topics. My learned colleague dealt with preliminary issues pertaining to the schedule. I'm not going to delve deeper into those issues, except to say, in the light of the notice that has been dispatched by the DPP's office, I'm inclined to provide a brief response thereto. Your Worship, the next topic that my learned colleague dealt with related to the charges preferred against the applicant. And he then further dealt with the topic around the state's case. And he spent quite some time dealing with the issues emanating from the state's case. From time to time, Your Worship, I would piggyback on some of the issues emanating therefrom. The topic that I will address this court on will be the applicant's case, and thereafter I will address the court on the absence of the provisions of section 60 subsection 4 A to E. So in essence, I'll deal with bail legislation in respect of this matter. Your Worship, I will then move to deal with the applicable law, inclusive of case law, in demonstrating to this honorable court that the interest of justice exists in this matter, and that the state, in its opposition of the applicant being released on bail, did not establish any of those factors as delineated in section 64 A to E. Your Worship, the background details in this matter and the germane facts in this matter are quite straightforward. The applicant approached this honorable court with an application for her release on bail. She deposed an affidavit by demonstrating to this court various factors that would show that the interest of justice permits the release of the applicant on bail. I would like to zoom into some of these factors emanating from the applicant's affidavit. I will demonstrate to this court that these factors, until now, and some of those have not been sufficiently, if at all, being addressed nor undermined by the state in opposition of bail. Your Worship, the affidavit, among others, touched on personal circumstances of the applicant. Now, this point is quite crucial when determining the suitability of the applicant to be admitted to bail. All the factors in her affidavit in respect of personal circumstances remain but undisputed. Now, it's tried law that where evidence remain undisputed, that evidence automatically should be accepted by this honorable court. My submissions are that the evidence, in as far as personal circumstances are concerned, it's not even riddled with any improbabilities. It's not far-fetched, succinct to the point that the applicant has strong family ties within the area where she resides, including strong family and occupational ties in the Republic of South Africa. Now, one will pause and check the affidavit by the state in opposition of bail and try and locate any aspect from the state's opposing affidavit which negates this very essential element of the applicant's case. It goes without saying, Your Worship, that there is nowhere in the opposing affidavit where this issue is being attacked by the state. Your Worship, we will then move to the travel documents. It's also a point that is common cause, that the applicant's travel documents have been confiscated. Her passport, according to her evidence, was confiscated. Now, what is the relevance and essence of this assertion? The relevance, Your Worship, I submit with respect that it touches on the very vein of Section 60, subsection 4B. That should the applicant be released on bail, is there a likelihood? And by the way, the inquiry there is not just merely a likelihood of the applicant for bail evading trial, but the likelihood that the applicant will attempt. And I'm saying this with emphasis. It is therefore incumbent on the state to produce evidence and not merely speculate, produce tangible evidence to the effect that there is a likelihood that the applicant will attempt to evade her trial. In this instance, Your Worship, the applicant made it quite clear, played open cards to this honorable court, that I have travel documents, but it has been seized. But it does not even end there. My learned colleague eloquently put forward a point that is crucial for the determination of this aspect. To say the state in its own opposing affidavit indicated how the applicant has been traveling in and outside the Republic of South Africa, coming back with no issues whatsoever. So even in the most extreme of cases, should it be found that the accused had a passport, could have been the accused would readily surrender such passport. But in this instance, the accused's passport the applicant's passport is confiscated. Now the question here, crisp question around this issue, is whether or not the accused has any other business to do or deal with outside the Republic of South Africa. And to this end, the applicant has not adduced such evidence, neither did the state in its opposition of bail adduce evidence to the effect that the applicant has some interest outside the borders of the Republic of South Africa. Your Worship, the applicant's family background has been placed on record through the affidavit. Even then, this evidence is not disputed at all. In actual fact, to lower the bar a bit, it's not challenged. The state has simply accepted the background details of the applicants with regards to her family being living in Port Edward, having 3 siblings. All of those facts were not just facts that are placed on record as evidence without any basis. The basis of us placing these facts in the affidavit simply to demonstrate to this honorable court that the applicant has strong family ties within the Republic of South Africa. The issue of the assets also features in the affidavit of the applicant. She indicated there the type of assets that she has. This augments the applicant's case to a large extent, mindful of the fact that the criteria can never be that anyone without assets might find him or herself on the back foot. But the reason why we mention the assets, particularly movable assets, by the way, movable assets to the value of R1 million, that is quite a substantial amount. Now, this aspect touches sharply the vein of Section 60, subsection 4B, in respect of whether or not that risk, that likelihood of an attempt to evade trial is completely diffused, because the inquiry should be, can the applicant afford to lose these assets? I will pause here with regards to this, because it's a point that one has to deal with it holistically, zooming into the argument by the state, to the effect that the applicant has everything to lose, particularly on the strength of the state's case. The state is saying Section 64, pardon me, Your Worship, Section 64B finds applicability here on the basis of the state's case being strong. By the way, Your Worship, this appears from the state's opposition of bail to be the only ground that the state presents to this court, the ground that the state is of the view is demonstrable of the likelihood existing. Now, at a later stage, I'm going to illustrate how some of the concerns could be cured, and this will be cured in terms of our own legislative processes. Legislation is mindful of some of the concerns that would arise in respect of admitting an applicant to be released on bail against the backdrop of a fear or concern that the applicant may attempt to evade his or her trial. My submissions are, Your Worship, that when we zoom into Section 64B, that we need not only look at this factor of the state in isolation, that my learned colleague pointed out assortment of anomalies emanating from the state's case. If the state's case, or if the state's submissions is to the effect that they have a strong case, my learned colleague has dealt the state's case a blow by listing a myriad of factors pointing out the shortcomings in the state's case. I would sufficiently, as I deal with case law and legislative provisions, I'll sufficiently deal with this aspect from the state's case. Your Worship, the applicant in her affidavit indicated that she does not have previous convictions, neither does she have any pending cases. This is quite crucial. This is quite crucial because this aspect, Your Worship, largely touches on the provisions of Section 60, subsection 4A, the propensity to commit further offenses if admitted to bail, and that's a likelihood, by the way. Your Worship, we need not delabor on this point any further. We need not overburden this court in respect of this aspect. We will take it that by law, this is a legal position and there is no two ways about it. The assertion with regards to registered cases has been dealt with by my learned colleague. But I must indicate that the bearing thereof, if there is any, of some other cases being investigated, that would not have any bearing whatsoever in respect of this application. Before this court, applicant has no previous convictions. Before this honorable court, the applicant has no pending cases. That's the end of the debate. We can't take it any further. Any desperate measure of trying to take those issues out of so-called registered cases is but unhelpful to us. Your Worship, there is also a mention of civil case. At what point do we even argue pending civil case? At what point do we even argue judgment of a civil court having a bearing on proceedings of this nature? But I will take it further, that the applicant has pursued a civil route to challenge the lawfulness and unlawfulness or otherwise of an apprehension in Tanzania. That's common cause fact. It's also common cause that and tried law, by the way, that the results, the cost follows the result. But the state comes to this court, also mentions the approximate amount of cost incurred this far. Must indicate that I find no relevance of that, particularly when we know, in terms of the civil processes, that a bill will be drafted, it will be presented to the taxation master for taxation purposes, and all those processes must be observed. But the relevance of that, could it be that all these are mentioned, issues are mentioned, the ones that I've pointed out, they are mentioned simply to cause an embarrassment on the person of the applicant? Because if I find no relevance in those submissions, there should be some way to try and analyze the rationale behind mentioning those. I respectfully submit, Your Worship, that until now, I have demonstrated to you that the evidence as presented by the applicant remains unchallenged. Now, Your Worship, there is a paragraph in our affidavit which can be located in page 8 thereof. And this paragraph deals with circumstances around my departure from South Africa. To this end, what we have here is the applicant for bail delineating to you her departure from South Africa. And the point that she is driving home is that I did not depart from this country voluntarily. And, Your Worship, she is saying, I am mindful of my right to remain silent. By the way, it's a crucial right in proceedings of this nature, including in criminal proceedings. It's a crucial right, the right of the applicant to remain silent. But she is saying, I'm taking this court into confidence to the extent that I just have to illustrate to this court the circumstances flowing from my departure from South Africa. Brief as it could be, but it does not negate the fact that she departed from South Africa involuntarily so. Now, anything to the contrary is but casting aspersions. Anything to the contrary is but trying to zoom into the rationality of the, or probability rather, of this version. Now, the state, in trying to rebut this, and I'm saying in trying to rebut this because I'm saying so deliberately, because it doesn't come out clear whether the state really rebuts this version and puts another version. Because then it will have come to this court succinctly that, wait a minute, you allege to have involuntarily exited the borders of South Africa, but we have on good authority that this and that happened. But what the state then attempts to do is to say, look, how could it be possible that you could involuntarily depart, and whilst there you crossed other borders or you came across other people? Couldn't you have issued SOS to the effect that I have a problem here? They take it further to say, couldn't you, by the way, there is a tracker which confirmed you being in KwaZulu-Natal with Thabo Bester shortly after the escape. Still not sure, perhaps the state they might have a sophisticated technology in terms of that tracker, but it didn't come out clear or come out at all from their evidence that the tracker showed the applicant's face, placed the applicant on the scene. It's merely about what I will term circumstantial. If I have to go there, circumstantial, that this is a vehicle belonging to the applicant. The only inference, I wouldn't say reasonable, an inference that can be drawn is that it was driven by the applicant. They furthermore downloaded some images. My learned colleague dealt with that. Obviously, the provisions of the Electronic Communications and Transaction Act, ACTA, are quite very clear in terms of reliance on video material, reliance on images that are to be used, and the procedure that has to be followed in order to have evidentiary weight. Not only that, Your Worship, but to also have such evidence admissible in court as evidence. What we have is pictures of people sitting, looking at each other, is two pictures. The reason the state is resorting to that strategy is simply to undermine the allegation that I involuntarily left the country. Your Worship, the state's approach there is problematic. problematic in that this is a space and zone of experts, by the way, in as far as the reaction of the applicant is concerned. Surely we don't have any form of expertise to even interpret someone's reaction and to be conclusive in terms of how a person could have reacted in a particular circumstances. Those factors are unknown at this moment. Hence, the defense, we actually find it very problematic that you can create those insinuations that according to the investigating officer, he signed out from his evidence by indicating the distance between South Africa and Tanzania. He leaves us second guessing the purpose. Could it be that they want to show this court the distance traveled? They take it further to say and draw some comparison that the accused number 5, having landed back into South Africa, later on laid charges against the state for lost items. Why could you not have done likewise? That's the question posed to the applicant. By the way, I'm making this submission, Your Worship, with respect, that our law in proceedings of this nature, or rather to rephrase, in criminal proceedings, or rather in terms of criminal law, there are certain crimes, or most crimes, which are not time bound. And this would lead me to prescription, among others, consideration of prescription. Can reporting of crime prescribe? You failed for 4 months to report this offense. Could it have any bearing? I'm just assuming that there will be a case. Assuming. And I'm not saying that that will be the issue. Because it is the prerogative and the direct prerogative of the applicant in respect of what do I do now? She decided how she decided it. The question that should arise out of this debate is whether or not this aspect has been undermined. And the answer thereto is a big no. The allegation, or rather the evidence by the applicant, has not been undermined to the extent that how she exited the boundaries of the Republic of South Africa. Your Worship, the evidence of the applicant, furthermore, on page 9, this deals with salient factual background on her arrest. Now, the state seems to be having a problem in the avenue explored by the applicant in challenging her unlawful disguised extradition to South Africa. By the way, it's a high court ruling. It's a high court ruling, part of which is still under litigation, sub judice. But the point I want to drive here, Your Worship, is that the applicant was brought to this country in the manner that has been delineated expansively in the application before higher courts. But she remains in custody from the 13th of April to date at Mangaung Correctional Facility. Now, the relevance of this evidence is that the applicant has spent a long period in detention. And I will demonstrate later on in my legal arguments that the reason for her to still be in custody cannot be attributed to her fault or fault on her part. But that being the case, the test here has to do with the fact that the applicant, or rather the state's case, is still under investigation. So the applicant did not play any role in the delays in finalizing in the finalization or conclusion of the investigations. So where the applicant is that she is still pending, or rather the case is still pending, investigations have not been completed. We don't have an indication how far the investigations will go, other than that on the 11th of October 2023, the state would have concluded the investigations, which would have to then deal with issues of trial, pre-trial issues, which by the way would take a while. So in essence, what we are saying is that the period envisaged for the matter to commence should be taken into cognizance when we determine this application. That the applicant, by the way, Your Worship, has a right to liberty in terms of Section 12 of the Constitution. Obviously, there is caveat linked to that, and I will address the court on those aspects at a later stage. Then, Your Worship, you will turn to page 10. Page 10 dealing with charges. Now, when we get to this stage, I am inclined to revert to the earlier preliminary submissions made in as far as the schedule of this offense is concerned. Your Worship, the defense and the state were ad idem in as far as the schedule of this offense is concerned. And this was based primarily and exclusively, by the way, on the charges that the state presented to the defense. The state, Your Worship, presented charges showing, among others, as indicated eloquently by my learned colleague, that Mr. Dlamini, that there is a count, it's a count 3, which dealt with the amount involved, and this is the count of corruption, and it related to Teboho Daniel Dipolo. The amount involved is 2.5. And the state also in count is, I think count 4 does not include accused number, the applicant, and it's settled. It's not, she is not here in terms of count 4. Now, it is on the basis of this count that we acceded to the scheduling of the offense under Schedule 5. Now, the state, after hearing our submissions, obtained a notice confirming the schedule from the DPP's office. Now, I want to take this position. There is evidence before this court. Evidence in opposing bail by Captain Flyman, who packaged these counts, stated the amount involved in count 3. And in count 3, Colonel Flyman refers to an amount of 85,000. Your Worship, we can peruse and peruse and peruse this affidavit. Will never find an amount of 2.5 million. We will never find it. Now we have this as evidence, and we have a charge sheet saying something else, and we have a confirmation from the DPP's office which deviates from the evidence. So we find ourselves seated between two versions, actually between one version and some submissions somewhere. Because this is a version, this is evidence. The opposing affidavit is evidence. Is what the state has. The charge sheet is what the state promises us. State is saying, when we commence this matter, we will have this. But for now, I have something else. Otherwise, I just need a more plausible legal reasoning for this disjuncture. Because to me, there is a disjuncture. Now, I submit with respect that the confirmation by the DPP will not cure this deficiency. It does not have any effect to cure it. The deficiency is incurable. So, according to our the charges, we have just placed the charges without mentioning the amounts. So I take it that even the state placed the charges and placed the amount, and those amounts should be admitted as evidence, and anything to the contrary will not have evidential weight or evidentiary weight. Your Worship, the applicant presented legal arguments in
Just interrupt you at this stage. I don't want to take you offline where you're busy with. I need you to just explain what you're saying to me again. I'm looking at count 3. The allegations in count 3 is against accused number 1, 2, 3, 4, and 5. And it is contravening section 3B, reading with other sections, prevention and combating of corrupt activities. And it says on the 14th of April, in the furtherance of common purpose, the accused unlawfully and intentionally directly gave or agreed or offered to give to any other person gratification. They offered him 2.5 million, but only paid him 40,000 to assist with the disconnection of the cameras. That is the allegations in count 4.
In count 3, Your Worship.
Count 3 against accused number 4, applicant number 4.
Yes.
And then if I look at the written confirmation by the DPP that was handed in today, it also refers to that the applicant before court will be arraigned on, amongst others, 4 counts of corruption with regard, in brackets, 2.5 million that was offered and only 40,000 and 85,000 was paid. And another 500,000 was offered and only 10,000 was paid. So, can you just explain to me where, in your argument, you said that there's a huge discrepancy? Just make it clear to me, please.
Thank you, Your Worship, and thank you for the opportunity. Your Worship, this is a legal argument that we are making. Against the backdrop of confusion that the state has brought into this bail application. I fully align with this Honorable Court with regards to the counts that have been read out. This is what we also have in our in the charge sheet, except the other counts there that I also new. I think the last count of 500,000 is not even part of this charge sheet. If this court can microscopically zoom into the charges. Now, where we are, remember that, Your Worship, we found it difficult to refer you to the affidavit of Captain Flyman because it's not numbered. But that is not a problem. I will refer you to that page by pointing out paragraph N at the top of that page. Now, according to, and this is evidence now, this is what we're dealing here with, evidence. What the state indicated, the state can say, I'm going to charge you with assault. And the state proceeds to lead evidence of theft. This is the analogy that I would like to bring to the fore for us to have a better comprehension of the direction we are taking. The posture we are assuming is a posture that says we have evidence before this court. This evidence is saying count 3. It's making reference to count 3, and this is corruption. And it refers to an amount of 85,000. Nothing else. Nothing else. And count 4, we are then referred to count 3 above. as though it's duplication, perhaps changes of names. I don't know. I don't want to address this on behalf of the state. But what I do know is count 3 refers to 85,000 rands in respect of accused number 1. According to the charge sheet, count 3 refers to an amount of 40,000 rands, and it creates an impression that there is an amount of 2.5 million at stake, at play here. The DPP also comes and confirms what is in the charge. Hence, Your Worship, in my earlier submissions, I put a disclaimer to say, much as the state is now presenting this notice, we are saying this should not be misconstrued because they are presenting it. It shouldn't be misconstrued to say it's the same as the charge sheet anyway. What they have in the DPP's confirmatory notice is the same. It's a duplicate of the charge sheet. Now, our argument here is, Your Worship, in what manner can any defects on evidence be cured? Can it be cured through submissions from the bar? Our law is quite clear on that. That should be part of evidence. Evidence must be led to that effect. What we do know is that we have the applicant allegedly having offered or paid whatever the issue is. And this can be located in this paragraph that I've referred to, but it's referred to as count 3. So that is where we are, Your Worship. That this situation ordinarily, and it's inescapable, that it creates a disjunction. We have evidence that contradicts the charge, that contradicts the confirmatory notice by the DPP's office. And there is no explanation there too, in as far as the evidence is concerned. That is where we raised a point in limine in respect of the scheduling of this offense. That this offense, against the backdrop delineated, cannot be said to squarely fall under Schedule 5. But this is Schedule 1. Now, in our address, because, Your Worship, the submission was not made as a form of an interlocutory procedure where we would want this court to make a ruling before we move on. Now, the approach is we are proceeding on the basis agreed before. But we are saying, court, please, you should not lose sight of this discrepancy that we uncovered in the state's evidence. That acknowledge that charges an accused with a particular charge, invariably, evidence must be led in respect of proving the elements of that particular charge. Anything to the contrary has got its own effects. So where we are now, we are saying, state, your evidence differs with your charge in as far as this is concerned. I hope, Your Worship, I've sufficiently addressed the issue that you wanted me to do so. In the event that there are still some residual aspects emanating from my submissions, I'm at your service to address those.
Thank you, sir. You made it clear. You may continue.
Thank you, Worship. Your Worship, then our affidavit deals with section 60. I'll park those because those are the legal submissions. And then final leg of our submissions, that the applicant is a candidate to be released on bail, and we address the amount which is an amount of 10,000. Now, Your Worship, if you allow me, as per my earlier submission, I indicated there that I will be then dealing with the law relating to bail. Now, I think this, to me, is a principle which I consider to be the bedrock of bail applications or bail legislation. The non-penal penal character of bail. There is our bail legislation and jurisprudence is replete with a whole range of case law in respect of that, and I will deal with some of the cases dealing with that aspect. Now, as a tried law, the applicant cannot be held in custody as a form of anticipatory punishment. And it's settled law. Now, where can we locate anticipatory punishment? My submissions are, we can locate anticipatory punishment through the posture adopted by the state, particularly with regards to the strength of the state's case, that the applicant might have to spend a long-term imprisonment. That argument cannot be loosely presented. And we cannot pay lip service in just absorbing this argument without any measure of interrogation. Now, for us to get to bail legislation, Your Worship, just want to locate this quickly, Your Worship, if you can bear with me. There is a case of State versus Mafe that I would like to refer to. If the court can just bear with me to locate it. I seem to have lost it, Your Worship. Your indulgence. If not, I'll revert to this point. It's a very crucial point, and it's a very crucial decision. I found it, Your Worship. Your Worship, this is the Mafe versus the state. And the citation on this matter is bracket A49/22, 2022 ZAWCH at page 108. In this instance, Your Worship, Justice Tulare pointed out the following, I quote, "In my view, fairness and justice call for the state to put the substantial facts upon which its charge is founded. First, that will be the first leg, and then the accused has an opportunity to provide an answer and show exceptional circumstances where applicable. And if needs be, the state gets an opportunity to rebut. In that case, a court can be well informed to form an opinion whether it has reliable, sufficient, or important information to reach a decision on the bail," unquote. Your Worship, I'm raising this authority specifically to demonstrate to this court how the state should approach a matter where they base the opposition on the strength of its case. Now, Justice Tulare succinctly point out the position that there must be substantial facts upon which the charge is founded first. My learned colleague, Advocate Dlamini, has already showed a lot of issues. So there are conglomeration of factors that in the defense position points toward the fact that we don't have enough at our disposal to deal with this issue. The issue of the charges. But furthermore, mindful of the fact that the applicant exercised her right to remain silent. But the information at our disposal, is it really reliable? Is it sufficient? Is it an important information to enable this court to really arrive at the conclusion? And in this instance, he takes the point further. Justice Tulare takes the point further to say, when we're doing so, I quote, "as envisaged in section 63 of the CPA, without infringing on the responsibilities and the rights of the state and of an accused." Now, what we have here, Your Worship, is evidence that is presented by way of affidavits. The state knows as well the probative value of evidence presented in that manner. But such evidence by law is not impermissible. It's more of the probative value. Now, the state is opposing. The state is saying, I have a strong case. And the state has presented a whole range of allegations, some of which, Your Worship, cast doubt, or rather, they are untruthful. There is, for instance, an allegation which I will deal with later, of the number of times the applicant has been in contact with the children. The state comes up with something else, which is not backed up by any shred of evidence. It's their word, and their word cannot be gospel. It's their word to say, she has not contacted her kids except once. Where did they get that information from? Why was it not attached as they went as far as downloading pictures. The state went as far as getting some documents from some other jurisdictions. But information that is pertinent to their case is just left hanging. And it's expected of this honorable court to just accept. Your Worship, I will then move to the next argument, or rather the next point. And in so doing, how I will approach this, Your Worship, is to just give a sketch out without regurgitating what the law says. We know what the law says. We know what Section 64A to E, Section 60, 6, 7, 8A, and 9 prescribes. But what I would want to do is to demonstrate to this court how these requirements of the law fits into our client's facts. So, Your Worship, we can all agree that Section 60, subsection 4A has not been rebutted. So the state has not established the likelihood that if the applicant was to be admitted to bail, that she will commit Schedule 1 offense. They have not dealt with that. In their own affidavit, nowhere has the state dealt with this matter. So we can accept that this provision of Section 64A has not been established. Okay. And now we have a way and a measure of verifying if indeed there exists any likelihood. And in this instance, Your Worship, I must indicate that the fact that the applicant has no previous convictions, has no pending cases, falls squarely under this section. The fact that the state has registered some other cases has no bearing. Now we move to Section 60, subsection 4B, evasion of trial. Your Worship, in this instance, The applicant has already submitted that there is no likelihood that she will evade her trial. Perhaps what we need to zoom into is to check what is meant by likelihood. Is likelihood a possibility? What is likelihood? And I would like to in this instance, Your Worship, I would like to deal with this question by zooming into the case of Bonginkosi versus the state. It's a constitutional court decision. And Your Worship, the citation is CC T27 of 2017. Your Worship, in this matter, I submit that the character of bail proceedings is two-stage. The first stage, and this is when we have to approach bail and give interpretation of sections 60, subsection 4A to E. What the court should follow, first, the court must determine factually whether the grounds listed in those sections or provisions are present. If they are not present, if they have not been established, then the applicant must be released on bail. That's the end of the debate. If it cannot be established that, because the state relies heavily on section 60, subsection 4B, that there is a likelihood that if she is admitted to bail, she will attempt to evade trial. If those factors are not established, that's the end of the debate. But if they are, those factors are established, it's inaccurate to conclude that bail must automatically be refused. So there is a second leg to it. And the second approach is that there has to be the determination of the interest of justice. And what does this engage? It engages judicial discretion, which must be informed by the overall standard of the interest of justice. So in light of these submissions, the case of the applicant in this matter, Your Worship, I submit that we managed to discharge the onus to prove that the interest of justice, and in this instance, Your Worship, should the court find the schedule to be Schedule 5, the onus to prove on the balance of probabilities that all the grounds listed there have not been established by the state. Your Worship, I notice it's quarter past 11. I think I will still take the last 30 minutes and I'll sit down, I promise. I'm not sure if we can still proceed.
We can continue. What do you say? Can we just hear from all the role players here? Does anybody need a break?
I have no problem in continuing. The clerk gives it a thumbs up. The interpreter gives it a thumbs up.
See, then we can continue.
Thank you. Thank you, Your Worship. So, Your Worship, I'll deal with section 64B expansively. The argument presented by the, actually evidence presented by the state is that the applicant will evade trial. I don't see where perhaps they mention she will attempt to evade trial. But let's suppose they will say she will attempt to evade trial. They are basing their argument on the fact that the applicant went out of the country. Your Worship, this argument is misguided and it's not a reflection of the reality. And I've already mentioned the application that is before the High Court with regards to this, and the petition that the applicant has filed with the Supreme Court of Appeal in relation to this matter. But, Your Worship, earlier when I was making my submissions, I indicated the right to liberty, which in a way is circumscribed by certain provisions of the Criminal Procedure Act, one of which is section 60 subsection 12. Now, we are treating the risk, and this is what the legislature had in mind in introducing this fact, this provision of the Criminal Procedure Act, that in the event the state has concerns with regards to whether the applicant will evade trial, this court is enjoined to invoke the provisions of section 60 subsection 12. It's empowered. So, according to section 60 subsection 12, the court can impose strict bail conditions, including the applicant being ordered to report at frequent intervals to the nearest police station. That in its own addresses this risk. We don't have any evidence before this court with regards to the applicant having any brushes with the law. So what we do have is just the issue of the applicant's likelihood that she will evade trial because of the charges that she is facing. Nothing more. In actual fact, the states showed a bit of desperation when it introduces a factor that was completely unsubstantiated with evidence, that for 11 months, and this is a naked factor, for 11 months, the applicant has been evading trial or evading justice for 11 months. In what manner, shape, or form? It doesn't come out completely from the evidence of the state. It's a standalone allegation, unsubstantiated. Submit, Your Worship, that such assertion should be rejected by this honorable court. State versus Branco is quite clear in respect of section 60, subsection 12. This is State versus Branco. It's a 2002, volume 1, SACR 531, W. In this matter, Judge Kachelia A.J. held that a magistrate should consider the ties that the accused has with South Africa. As such, in terms of this principle, Your Worship, we submit that the Honorable Court should consider the applicant's personal circumstances as alluded to in her affidavit. Your Worship, to finish off the point around section 60, subsection 4B, I would like to also draw the court's attention to section 66. In this instance, what we do have, according to the state, is that the state has got a strong case. As indicated, they don't take it any further. They don't dispute that the applicant has strong family ties. They don't address all the provisions contained in section 66. And Your Worship, I would like to, if the court can indulge me, I would like to make reference to that section quickly. Your Worship, in terms of, I'll just get there quickly. Now, in terms of section 66, and in considering whether the grounds of section 4B have been established, Your Worship, there are 10 factors that must be taken into account. 10 factors. And I just want to locate my notes on that. Pardon me, Your Worship. Okay. All right. But one of those factors, Your Worship, is one, let me do this, Your Worship, quickly. Firstly, Your Worship, the emotional, family, community, or occupational ties of the accused in the place at which he or she is to be tried. The assets held by the accused. The means and travel documents held by the accused which may enable him or her to leave the country. The extent, if any, to which the accused can afford to forfeit the bail amount or the amount of bail which may be set. The question whether the extradition of the accused could be readily be effected should he or she flee across the borders of the Republic. The nature and the gravity of the charges on which the accused is to be tried, the strength of the case against the accused, and the incentive that he or she may in consequence have to attempt to evade his or her trial, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted, the binding effect and enforceability of bail conditions which may be imposed, and the ease with which such conditions could be breached, or any other factor which, in the opinion of the court, should be taken into account. Your Worship, what the state is relying on is paragraph G and H. But I submit that even those paragraphs, the state has not really provided this court with tangible evidence to suggest that indeed the strength of their case would lead to the applicant absconding from this matter. By the way, one would not even lose sight of the fact that there are 10 co-accused in this matter. If I'm correct, 9 of whom have been out on bail. They are facing the same charges, not similar, same. The 4 who were actually released on bail, 3 of them had to appeal, and the 4th one was released based on the new facts as a result of the ruling of the High Court. None of them have absconded. Because if we check the provisions which the state relies on, those provisions finds applicability with regards to other co-accused. The same with the next paragraph, H, the nature and gravity of punishment. They also face the same. And what we need to submit here is that paragraph A is in favor of the applicant in any event. B, C, she has no means of traveling. She doesn't have travel documents. But, Your Worship, the binding effect of enforceability of bail condition, paragraph I. We don't have a situation where the co-accused in this matter have violated any of the conditions. It is accordingly my submissions that the state hasn't established the existence of a likelihood of the applicant evading or attempting to evade trial. There's no iota of evidence. It's just allegations that are there, and the reference that I've made regarding other co-accused stands to prove that indeed this may not be a factor as strong as the state alleges. Your Worship, when you deal with section 60 subsection 4C, the state's opposition is one line. There's a possibility that the applicant will interfere with the evidence. There's nothing else. We're talking here of evidence. No evidence was presented to this honorable court to the effect that the applicant at some point made such attempts. The proposition by the state is misguided and should be rejected. I submit, Your Worship, that this factor as well has not been established by the state. Because we're talking here, the law is quite clear, the position is clear. There has to be a likelihood. A likelihood is based on evidence. The applicant, on the other hand, is saying, I have no knowledge of the identity of the witnesses that are going to be called. In actual fact, Your Worship, one will not resist the temptation of referring to co-accused because they are part of this matter. There's not been any evidence, once they are out, that there's been fiddling or attempt to intimidate or interfere with witnesses with the state's investigations whatsoever. My learned colleague can attest to that. So what we have here is, can a fear that is baseless, a concern that is not based on legal grounds, be used in opposition of bail in respect of even this provision? Section 64C, there is no evidence before you to suggest that the applicant will interfere with the investigations or intimidate witnesses whom she doesn't even know. There's not been, the only allegation close to that is that she knows some of the witnesses. Who are they? They don't mention. But to take it further and to disrupt the chain, should it be found that, oh, she knows a particular witness, so what? If evidence is not presented to suggest that her knowledge or proximity of this witness is an indication of some sort that she will in any way intimidate or interfere. We don't have that before us. I will move to section, and in this instance, Your Worship, pardon me, I have the authority of State versus Dlamini, Dada, Jubek, Skitekat. That's the constitutional decision. In actual fact, that is the landmark decision based on considerations that the court should have on in bail applications. But, Your Worship, Section 60, subsection 4D also find no applicability. To this end, the assertion by the state is that if she's released on bail, she will undermine the, among others, bail system and everything. Where is evidence? And on what basis is the state relying on this, on that conclusion? Because for a conclusion to be made, there has to be a process to prove it. We don't have proof to that effect. Section 60, subsection 4E. And this is quite interesting because legislation deliberately starts with in exceptional circumstances. But in this instance, Your Worship, that if the applicant was to be released on bail, there will be public disorder. I think this point was also competently addressed by Judge Mhlambe in the bail appeal launched by the 3 co-accused in this matter. Then it was even a situation of few people demonstrating, perhaps few. But in this bail application, there's none. On what basis are we making reference to this position? On what basis? Because what we do have here is a situation where the accused is entitled, because she has a right to liberty, and there's not been any public disorder, at least from where the state in its own affidavit would have mentioned it. But what the state mentioned, Your Worship, in their own affidavit is simply that there will be public disorder. That's it. And I will refer to the last paragraph. Where they are just making mention of the fact that the applicant has been appearing with accused number 5, and she appears to be showing affection to each other. They were holding hands and smiling at each other. What is the state attempting to say here? In relation to what? Is it because the applicant alleges that she was instructed and commanded to alight into a vehicle and leave the country? What does that have to do with if the applicant in that particular time, they are saying she was smiling? How does that negate what happened 4 months ago? And in what state of the mind and in what psychological state is the applicant currently? Do we know? I've submitted, Your Worship, that this is a matter that will be dealt with sufficiently during trial. What we do know now, Your Worship, is that the application, rather, the assertion by the state to the effect that they have a strong case, the applicant says, I'm not guilty. It closes the debate. It's a matter of trial. Your Worship, I'm just about to conclude. Can I just approach my learned colleague, please? Your Worship, I've just canvassed this with my learned colleague. Just needed some 5 minutes comfort break, if it pleases the court.
Could you please just let me know when you're ready to proceed? I'm going to take a short adjournment.
All right. As the court pleases your worship, I'm ready to proceed. I'm indebted to the court's indulgence in having a comfort break. Your worship, I think I've got 3 legal points that I'm going to present, and then I'll conclude. Your worship, in as far as Section 64B is concerned, your worship will notice that this is the bigger part of the submissions sharply focuses on Section 60 subsection 4B, because from the opposition one picked it up that is the essence of the opposition. Now, in our evidence, we also attached a confirmatory affidavit. Now, the reason for that was to deal with this concern. I call it concern deliberately, your worship, because as I indicated, there is no evidence to back it up. Now, the concern that the applicant will evade her trial is addressed by the fact that applicant has an alternative address. And one would not also lose sight of the assertion by the state with regards to misleading the investigating officer regarding her residential address. I think this point again was raised sharply by my learned colleague. There is just no way that by her providing residential address, she could be viewed to have misled the investigating officer. Misleading should actually be in the event that she gave a wrong address. She gave the right address. This is according to the state's case, an address where she last stayed in. Now she is saying, well and good, I'm no longer going to stay there. I've been in custody since April. If I am released from custody, I will stay in the other address which has been confirmed. What we do have now, your worship, is her version in as far as this address is concerned. This address has not been rebutted in any way by the state. In actual fact, the state has confirmed the correctness of this address. In as far as, in fact, they even attached a date that this person has been staying there since a particular year. But before then, the said person stayed in another address. I wouldn't go as far as dealing with other aspects which the defense find to be highly offensive to the character of the applicant and the person involved. But those issues were dealt with by Advocate Dlamini. So, your worship, then we have to deal with the point I made earlier of the character of a bail application. And in this instance, I'll refer this Honorable Court to State versus Viljoen. Your worship, this is a 2002 Volume 2 SACR 550. It's a Supreme Court of Appeal decision. In this matter, the court held that caution must be taken not to turn every bail application into a drawn-out trial. We can't have this bail application now being a trial before the actual criminal trial. It's not for this honorable court, it's not for this forum to determine the guilt or otherwise of the applicant. And the court in that decision also emphasized that it could not have been the intention of the legislature that bail applications would be a dress rehearsal of a criminal trial. As indicated, the huge emphasis that is placed by the state on regarding the charges and a plethora of other allegations on the evidence and on all of that, that approach, Your Worship, is offensive to the principle enunciated in State versus Atchison. And State versus Atchison, the citation in that matter is 1991, volume 2, SA 805, NM 822 A to B. In this matter, Your Worship, the court emphasized that the bail applicant cannot be kept in detention pending his or her trial as a form of anticipatory punishment. The court pointed out that at the bail stage, the presumption of law is that she is innocent until her guilt has been established in a proper forum. It was held then that the court will therefore ordinarily grant bail to an applicant person unless this is likely to prejudice the ends of justice. Now, what do we have before you? Do you have any evidence to suggest that the ends of justice will be prejudiced if the applicant is admitted to bail? The answer is no. In actual fact, the applicant has demonstrated that the interest of justice permits her release on bail. This takes me to a point that I wish to sharply raise with regards to this application, and particularly with reference to the applicant. That a person may be in the public's subjective, and I'm intentional and deliberate about it, the public's subjective view, factually or morally guilty of a crime. But that view is subjective. And that view is not based on any legal grounds. Factually, morally, subjectively, a person is subjected to a court of public opinion. But that itself, that does not say that she will be proved to be legally guilty. There can be condemnation which does not talk to the essence of legality. And in a state such as South Africa, which is under the rule of law, only legal guilt counts. To convict a person in any other way will amount to vigilantism, mob trials, even anarchy. Not forgetting that a person will be found guilty in a court of public opinion, relegating the court processes and the rule of law to nothing but a process that would not seek to achieve justice. Your Worship, I submit as I conclude now. We have made a relief, and our relief in this instance is that the court, evaluating and analyzing the evidence holistically in totality, the state did not present evidence that establishes any of those aspects enunciated in section 64A to E. In the absence thereof, in their failure to do so, I submit, Your Worship, that, and in the event the court finds the schedule that the accused or the applicant is facing falls squarely under the ambit of Schedule 1, then the onus which would have shifted unto the state to prove on the balance of probabilities that the interest of justice does not permit her release on bail, that onus would not have been discharged by the state. Conversely, the applicant has demonstrated a very strong case in respect of her eligibility as a candidate to be admitted to bail because the dictates of the interest of justice demand so. That being the case, Your Worship, I wish to address the court on the appropriate amount that the accused will be in a position to afford. In our papers, we outlined her personal circumstances. The fact that she was running a company, a skincare company, and Your Worship, it's really regrettable that she didn't have the opportunity to really deal decisively and robustly with allegations contained in the opposing papers, including the allegations that she was disbarred or something to that effect by the Health Professionals Council of South Africa. Something that we would have dealt with sufficiently because there is proof to the contrary. That being the case, she has been out of pocket. She has not been generating any income for a period of more than 4 months now, since she's been in custody. It is thus our submissions that an amount of 10,000 in light of her personal circumstances and looking into the case at hand. But furthermore, one cannot resist the temptation to zoom into what happened with her co-accused. They were admitted to bail of an amount of 10,000. We are of the view that that amount of 10,000 rand is an amount that would be fair under the circumstances, that any amount higher than the one proposed would be tantamount to refusal of bail, that she is a correct candidate to be admitted to bail, and that bail in the amount of 10,000 rand should be fixed. Your Worship, this brings me to the end of my address. I'm indebted to court for allowing me to proceed and deal with these issues expansively. Your Worship, the defense reserved the right to replicate after the state submissions. I will pause for now. Should there be any issues flowing from my address, which the court would want to canvass and get clarity on. The defense is at your disposal to attempt to address some of those as a court basis.
Yes, thank you, Chief. I am ready.
Okay.
Let's swap seats, my brother.
Rather, we should cross the floors. Thank you.
I have been handed all the exhibits that was given to me on the previous occasion, and it appears that I made a mistake with regard to the marking of the exhibits. The affidavit in support of the bail application is Exhibit H, as correctly marked, and then the affidavit of Mr. Flyman in opposing the application should be Exhibit I, so I'm going to amend it to Exhibit I. If you can do the same on your records, please. Which will then make the certificate of the DPP Exhibit J.
As a court basis.
As a basis. Can I, the United States request that the heads that already the court has already confirmed to have received also be marked to form part of the record?
It will be the Exhibit K.
That will be K. As if the court will bear with me, the state has to now reply or to address you on and to touch on aspects that have been raised by my two learned colleagues over 2 days. Yes, there are aspects that I wish to deal with first before I get into my written address. In fact, as I get into my written address, Your Worship, I will here and there briefly stand off my written address to address some of the aspects that might have been raised. Yes, at the beginning of these proceedings, both the state and the defense agreed that the applicant is facing, amongst others, charges falling under Schedule 5 of the Criminal Procedure Act 51 of 1977. This was based on the fact that the charges against the applicant include corruption in contravention of Section 3A and B of the Prevention and Combating of Corrupt Activities Act number 12 of 2004, and fraud which the state alleges were committed by a group of persons acting in the execution and furtherance of a common purpose or conspiracy. Let me pause then here, Your Worship, and address you on aspects that were raised in relation to the schedule. Indeed, the DPP has now since confirmed the schedule, but there are aspects that have been raised which, in my view, are misleading and not totally correct. And that relates to the charges, Your Worship. Let's look at count 3, that the defense alleged is the sole charge that may speak to Schedule 5. And this they based on the fact that in the affidavit of the investigating officer said under oath that the applicant paid an amount of 85,000 rand. And therefore, in their view, the 85,000 rands falls short of the threshold, which is 100,000 rands, which then makes it a Schedule 5. Let us define what corruption is. The charge is very clear. Count 3 states, amongst others, that the accused in furtherance of a common purpose unlawfully and intentionally directly gave out or agreed or offered to give to any other person. Then it specifically states who the person in question is. In the furtherance of a common purpose, they offered a certain gratification, specifically to Thabo James Dipolo. Who are these people that act in furtherance of common purpose? Accused 1, 2, 3, 4, and 5. Now it goes off to say any gratification, to wit, to offer him 2.5 million and paid him 40,000 for the assistance to disconnect the cameras and recording, to help him to facilitate the escape of an inmate, and he specifically mentioned the name of the inmate, whether for the benefit of that person or for the benefit of another person in order to act personally or by influencing another person to act in that manner, then it counts. The assertion that this count relates solely to 85,000 is not correct. Even if there was not a cent paid out, corruption is complete. Once there is an offer or to accept any gratification, in this instance, what is the gratification? The gratification in terms of the charge is 2.5 million rand. The commission of corruption is complete. It is on that basis that the state is saying this indeed is a Schedule 5, because this offer or agreement is committed by a group of people in the furtherance of a common purpose. What is the common purpose? Is that Thabo Bester must escape. What is the gratification? 2.5 million rand. Corruption is complete. Even if not even a cent was paid by any person, corruption is complete. Then let us go to count 4. I must concede that when you look at the top, where it is written count 4, it says accused 1, 3, and 7. But for the reason unknown to me, that's where the defense ends. When one looks at what the charge is, what the charge is against the accused. It says, contravening Section 3A, read with Sections 1, 2, 24, 25, all those subsections of the Prevention and Combative of Corrupt Activities Act 12 of 2004 as amended. Corruption. Then it states, receiving a benefit. Then it lists the accused. It says accused 1, 2, 3, 4, and 5. Why they wouldn't read this into record, nobody knows. But the fact of the matter is, I concede there could have been, when one looks at the definition and what the crime is, accused number 4 is included. And what is the gratification in that respect? 2.5 million rand, whereby 40,000 rands was paid. Even if the 40,000 rand was not paid, the corruption is complete. We're talking of 2.5 million rand. But that does not end there, you see. Let's look at what count 14 says. Count 14 specifically says accused 4 and 5. Who are accused 4 and 5? Number 4 is the applicant before court. Number 5 is the person that the applicant says kidnapped him to Tanzania, which is Thabo Bester. What is the gratification there? The gratification is 105,000 rand. What was it for? To assist accused 5 to escape from G4S Correctional Centre. Who was paid? Sinoe Matswara. Is it obligatory to state that when one has already said all these people, which is 4 and 5, acted in the furtherance of a common purpose? What is the gratification? 105,000 rand. Whether the 40,000 rand was paid or not, corruption in terms of our law, South African law, is complete. Those are the charges that, and the true position of our law that my learned friends turned around to fit themselves, to exclude the Schedule 5. But all these charges I have read out, and as confirmed by the DPP, are within the ambit of Schedule 5. Worship, let me state the following. When Advocate Dlamini was addressing you, %80 of his address, I would say, consists of a personal attack on the prosecutor and the investigating officer, going as far as calling us names, but I'm not going to address the court on that. But he went on to make a very serious allegation against the prosecutor, being myself, making me guilty of unlawful conduct, as he stated it, by amending the affidavit of the investigating officer. Worship, that is not true. Fortunately, this happened in an open court. The record is there. And fortunately, at that time I read out the affidavit of the investigating officer, I had already gave his affidavit to the court. So at that stage, that affidavit, which is part of the court record as we speak, was with the court, and it has not been amended in any way. But look what he does. He accused me of that unlawful conduct, and yet he is the one who started with the unlawful conduct. The court will remember that he changed the numberings of the affidavit of the applicant and said, this is a mistake, this is a mistake. Not only one, but three, to say this must be regarded as a mistake. Did he now take it to the applicant to confirm and to initial that? No. And yet, and then let me address this aspect that he never placed it on record. What is that I changed from the affidavit? But let me remind the court what happened. I was reading out the affidavit. Granted, the affidavit, not numbering, but when I counted, it's on page 5. And I read, upon digging this grace, I read it into the record, and then I said to the court, I think this must read grave without changing anything. I still have it unchanged. The court has it unchanged. Did I change anything? No. And yet, he emphasized about this unlawful conduct and the unlawful procedure. Joseph, so much has been said about the investigating officer and the state. And Your Worship, I need to state insofar as that aspect is concerned, and I want to place it on record, that despite his reservations and his accusation of the conduct of the state, he did not object to the admissibility of that affidavit, despite him believing that the prosecutor has amended the affidavit, which I should not have. He did not. He had a right to stand up and say, I object to the admissibility of the affidavit. Coupled with that, Your Worship, even Mr. Motloung touched a bit on that the state has, or the investigating officer have appended a picture, the authenticity of which has not been proven. That was handed in as an exhibit, and it was accepted. The defense did not object to the admissibility of that picture on the basis of authenticity. It's only now in their address that they now state, they should not have done that. But look at them. In the confirmatory statement that they handed in, there's a copy of a bill from the municipality. Has that been authenticated? So the very same conduct that they accuse the state of, they commit the same thing. And they did not object even at that stage to say, we object to the admissibility of that. It must first be authenticated. That is what the procedure in this court demands. The third aspect I need to raise, Your Worship. Throughout their address, both of them, they've been saying the state has failed to prove 1, 2, 3, 4. the state has failed to prove this and this and that. What does our law say? The law. In Schedule 5, it says the following: notwithstanding any provision of this Act, which is the Criminal Procedure Act, where an accused is charged with an offense referred to in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless, and I need to emphasize this, unless the accused, not the state, unless the accused, having been given a reasonable opportunity to do so, do what? Adduces evidence which satisfies the court that the interest of justice permits his or her release. The duty is on the applicant to do what? To adduce evidence. What kind of evidence must she adduce? The evidence that satisfies this court that the interest of justice permits her release. This position, Your Worship, according to my written submissions, is reiterated in State versus Rode, 2020, Volume 1, SACR 329, Supreme Court of Appeal. At paragraph 25, the court reinforced the principle that the applicant carries the evidential burden on account of Section 60B to persuade the court that the interest of justice permits her release. Not for the state to do anything. All what is reiterated here is the section talks to the accused, the applicant. As said, Your Worship, the onus is on the applicant to satisfy the court on a balance of probabilities that the interest of justice permit her release, that he should read her release. As correctly pointed out by Mr. Mutlow, Section 60, subsection 4, provides, amongst others, that the interest of justice do not permit the release from detention of an accused when one or more of the following factors are established. Then it lists A, B, C, D, E. The first A deals with the likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense. Advocate Dlamini, in his address, as much as I would have wanted to avoid mentioning them by names, but the fact of the matter is we have a situation where two legal representatives addressed the court on the same aspect. Therefore, to do the distinction, they will have to forgive me that I mentioned them by name. Advocate Dlamini says, and I remember he even wielded the affidavit of the investigating officer saying, nowhere is he saying anything about Section 64A. What does the law say? It says, amongst others, that the interests of justice do not permit the release from detention of an accused where one or more of the following factors are established. One or more. The investigating officer could have, in replica, in opposing the affidavit, only have relied on one factor. In terms of the law, he could do that. Only one factor. Does not need all factors to be addressed. If he has nothing to tell the court about that subsection, why still include it? And where he does include, like the section 64C, where he does include, he's been criticized. Wow, 2 lines. Where it does not include, also is a problem to the defense. But what I'm trying to raise here, Your Worship, is that the legislature deliberately says where one or more of the factors have been established. And who needs to do that? The applicant, not the investigating officer. The applicant. Your Worship, both the state and the defense adduced evidence by way of affidavits. Neither the state nor the defense could challenge anything on the affidavits because they could not cross-examine. And therefore the court did not have the benefit to can make judgment on the credibility of any person. And yet so much has been said by both defense counsels about the credibility of the investigating officer, which is not challenged. At some stage, he was said to be decorating. What decoration? Your Worship, it is therefore my submission that the court will have to consider whether the applicant has discharged the onus that is on her to satisfy this court that the interest of justice permits her release. Both my learned friends, when they addressed you, they introduced evidence through a back door. They address you on aspects that cannot be found in the affidavit of the applicant or that of the investigating officer. As I go along, I will deal with those aspects. But one aspect that specifically Advocate Dlamini placed on record, it was in relation to the suspension of the applicant's membership of the medical council, which is in the affidavit of the investigating officer. When he addressed you, it cannot. In fact, the applicant, nowhere in his affidavit does she say anything about it, about the suspension. And yet, when Advocate Dlamini addresses you, Your Worship, he specifically says, the applicant informs me that I don't need a certificate to practice in the field that I was practicing at the time of my arrest. It's nowhere in the affidavit. He's the one who raised it. And yet, every aspect that the state or the investigating officer mentions in his affidavit, the court has been asked one and the same question. Where is proof? Where is that evidence? And in conclusion, my learned friend was quite correct, and I want to commend him for that. In conclusion, he cited a case law that specifically says the court must caution not to take 10 bail applications into trials or protracted trials. And that's exactly what they are saying the state must do. They say the state must prove all these allegations. They've been saying that from day one until now. And Your Worship, that is not the approach. It's about factors which are mentioned in the subsections that I have already hinted, which the court must then consider when deciding on the issue of whether it is in the interest of the applicant to be released on bail. Your Worship, my 4.2 paragraph, I state, on the other hand, in the affidavit on page 10, at paragraph 10.1, the applicant confirms that she has been informed of the charges against her and goes on to list these charges. Then she goes on to say at paragraph 10.3, she has been advised of a right to remain silent and not to reveal the basis of her defense, and that should she reveal the basis of her defense, it may be used against her at the ensuing trial, and as such, she decided to exercise and assert her right to remain silent and not to disclose the basis of her defense until the appropriate time and forum. Thus, acting on legal advice, she chose not to challenge the strength of the state's case. Your Worship, this being one of the factors for consideration, I'm happy that both my learned friends have touched on it, and therefore they are aware of what the law or the subsections provide when it comes to bail applications of Schedule 6. It specifically refers to, amongst others, the strength of the state's case. And in his address, Advocate Dlamini says the state's case is so poor. I wonder on what is he basing that? And the court shall remember that in the beginning, he told the court that the investigating officer, in the first 5 pages of his affidavit, has made a very nice story. He says, he calls it a story. But when you look at all those 5 pages, he is telling the court what the case against the applicant and his co-accused. And specifically, he made reference to issues that I believe are in the favor of the applicant. He himself, he raised it in his affidavit. For instance, 5.1. He's the one who's saying the applicant is a married woman. And then he goes on to tell this court what the case is against the applicant and his co-accused. But of importance, because the defense says when the court looks at the personal circumstances of the applicant only, she has made the case to be granted bail. And they say that has not been challenged. There's no evidence before this court contrary to that. But let's look at the personal circumstances that the investigating officer stated in his affidavit, which the defense is silent on. They did not say anything about it. Amongst others, the investigating officer attached her founding affidavit that was filed in the High Court in Pretoria. For what reason? For the reason that she wanted the court, amongst others, to declare her as a customary wife of the deceased. At that stage, the deceased was mentioned as Thabo Bester. It's a customary wife. They don't comment, they don't say anything. And that is the affidavit that the applicant herself submitted to the High Court. And they say the state has failed to give substantive evidence or issues to show the charges. What does it say in 5.5? By the way, 5.5 is one of those 5 pages that we are told are stories. And this is, amongst others, showing what evidence the state will lead during trial. He says at 5.5, on or about the 7th to the 13th of April 2022, the applicant collected and claimed an unidentified body, which was unclaimed from State Mortuary in Bloemfontein under the false pretense that the body was that of her father, Zingiza Magada. This is what the IO says he has when the matter goes on trial, and how, what role the applicant played. And then he goes on to say she then arranged for a funeral and burial of the said body in the early hours of the morning, citing cultural practice. And he goes on to say when he, the investigating officer, and the police dig the grave to exhume the body, they found rotten meat inside the coffin. He's giving us what the state case is against the applicant. And he says, during my investigation, that is now 5.6, I discovered and confirmed that the applicant booked into a boutique hotel in Bloemfontein during the periods 24 to 28 March 2022, 29 to 30 March, and 13 to 14 April 2022. One would ask, as time and again I hear that question, so what? She has booked into a boutique in Bloemfontein, so what? But what the investigating officer is showing us is that it is at that time that accused 5, during that period, that accused 5 escaped. According to the applicant, who is accused 5? Accused 5 is the person that kidnapped me. and took me to Tanzania. Have they addressed the court on that aspect of the affidavit of the investigating officer? No. Perhaps in replica, I'm sure. And then he goes on to say at 5.8, I'm saying on the 23rd April 2022, the applicant and accused 9 approached the mortuary at National Hospital Bloemfontein to claim another unidentified body. Is that not one of the charges that talks to an unidentified body? Let's look at the charge of defeating the ends of justice in count 11. And let's look at count 7, the violation of a body. Those are some of the counts that are there, and he is giving what evidence he has to prove those counts. And yet, we are told time and again, the state presented no evidence, nothing, on the strength of the state's case. And yet, the defense has not challenged this, what appears in the affidavit under oath of the investigating officer. They did not do that. Why? Perhaps it was focusing on how the affidavit was drafted and the like. But these have not been challenged. And look at 5.30. It is under oath by the investigating officer. On 5 May 2022, the applicant, together with accused 2, who is accused 2? It's her father, claimed the charred body found in cell 35 as that of Bester. And then it goes on to say, in claiming this body, the applicant submitted an affidavit dated 5 May 2022, commissioned at Polokwane to a G4S official, wherein she declares the deceased, and he puts it in inverted commas, to be her partner who has no other relatives. Is that not what the charge, does it not speak to the charge? Does it not speak to what case he has against the applicant? And then in the latter part, the investigating officer start by giving the court all this to say, this is the case that I have against the applicant. Then he concludes by detailing the different charges and stating what evidence he has. For each charge, he will indicate direct evidence, what Mr. Dlamini referred to, stroke eyewitness. This is the evidence that he says he has. And this is the evidence that the defense says, keep on saying, the state must produce. We are not busy with trial. We are busy here with a bail application, where certain factors must be considered. Worship, continuing with my written heads, disclosing at page 4, disclosing the basis of defense which she has a right not to disclose at this stage, and challenging the strength of the state's case are two different matters. They keep on saying, I've been legally advised, I have a right not to disclose the basis of defense. That's not the issue. Of course, I confirm. She has a constitutional right of silence at this stage. But that does not mean she must not challenge the state's case. She must not challenge the strength of the state's case, which is one of the factors that the legislation says must be considered. Instead of challenging the state's case based on the charges solely, she goes and gives us an account of her kidnapping. And then once again, Your Worship, let me refer, insofar as the strength of the state's case is concerned, what does our higher court say in that regard? Let's look at State versus Jonas. It's a 1998, volume 2, SACR 677, SCA, the Supreme Court of Appeal decision, where amongst others, the court says, to be successful, the applicant had to show by adducing acceptable evidence that the state's case against him is non-existent or subject to serious doubt. Not to address the court and say, the state has got a weak case, it's poor. What SCA says, the applicant must adduce acceptable evidence that the state's case is non-existent, as they contend. And as I indicated, Your Worship, challenging the strength of the state's case and exercising your right to silence and not to disclose the basis of defense is two different aspects. And Your Worship, let me also refer, Your Worship, is there in my written submission, page 4, State versus Koch, 2003, volume 2, SACR 5. It's also a Supreme Court of Appeal judgment, where at paragraph 11, the following is stated: the strength or weakness of the state's case must be given consideration in determining where the interests of justice lie for purpose of section 6011B. And it further goes to say, in that case, the state has either failed to make a case or has relied on one which is so lacking in detail and persuasion that a court hearing a bail application cannot express even a prima facie view as to the strength or weakness. The accused must be given the benefit of doubt and then must be released. Is that the position in this case? The investigating officer has given a detailed account of what the charges are, how the applicant is linked. Your Worship, in dealing with the circumstances around her departure, as I'm saying, I'm not sure if now somehow disclose the basis of defense regarding what, because she has not been charged there is no charge before this court regarding her departure to Tanzania. But nonetheless, okay, it's fine. Defense gives us an account. She alleged she was instructed and commanded by accused 5 to get into a vehicle and leave the premise to a destination unknown to her at the time. And at this stage, it must be remembered, or who is the accused 5? Accused 5 is the person that the investigating officer in his affidavit, which is not being challenged in any manner by way of evidence, is a person who was sentenced to life and who was supposed to be at G4S prison at the time. That is accused 5 that the applicant says kidnapped her. And in her application or affidavit, her address appears to be the address in Gauteng. G4S prison is in Bloemfontein in the Free State. Where and how they met, they decide not to reveal that to the court. And yet, they say, accused 5 kidnapped me. They do not reveal where they met, how he kidnapped her at all. Is it by gunpoint? Is it by knife? How was she kidnapped? If indeed we have to believe she was kidnapped. It is my submission that in this aspect, she's not taking this court into her confidence. And yet, the investigating officer is told, we are told, he's not giving evidence, he's not getting into detail of how the charges, and yet, that's what the applicant does. We do not know how she got kidnapped and where. Nonetheless, the investigating officer in his affidavit gives reasons why he does not buy into this story. He gives reasons. We are told that no one in this country, no one even in this court, can really say how she got into Tanzania. But what the investigating officer is saying, which they are not saying, is that anyhow she found herself in Tanzania, she did not use a passport, which is a requirement for her to get into another country. That has also not been disputed, not by evidence, and not even by their own addresses. That the passport was not stamped. How then do you find yourself in Tanzania having been kidnapped? They don't even say what, where, which border they crossed. And yet they are the ones who raised this, that this is how I found myself in Tanzania. The investigating officer, all that he says is, what I know is that he did not use a passport. And then Your Worship, Advocate Dlamini, when addressing you on the aspect that was raised by the investigating officer of a travel abroad, the investigating officer says, from her passport, he could see that she has been abroad 23 times, or she has traveled 23 times. And Advocate Dlamini says, so what? Is she not allowed to travel abroad? What's wrong with that? What he does not address is that the difference between her traveling 23 times or so abroad and this particular traveling that we are busy with is that in this instance, the passport was not used. In the other 23 instances, the investigating officer says there are stamps that show that she has been going. But in this instance, the investigating officer says, this time, she has not used the passport. What does that mean? It can only mean that she unlawfully crossed into Tanzania. How? By way of kidnapped. By who? Accused number 5. Do we have that? No. Joseph, in her affidavit, she says the kidnapping took place on the 17th of March, 2023. And the investigating officer in his affidavit says they were arrested in Tanzania on the 7th of April, 2023. That means from the 17th until the 17th of March, 2023 until the 7th of April, 2023, the applicant has all along been with the kidnapper, with the person who has kidnapped him, because they were arrested, both of them were arrested at the same time, according to the affidavit of the investigating officer, together with another person from a foreign national. Joseph, I state here at paragraph 4.3.3 that kidnapping is a criminal offense. And then Snyman described kidnapping as unlawfully and intentionally depriving a person of his or her freedom of movement. This is what the applicant says happened. And the investigating officer then raises an issue, Yoshi. He says, if that is the case, why did she not open a criminal case? That question of the investigating officer is answered by Advocate Dlamini. What does he say? He says it's the applicant's choice whether to open a case or not. It is her choice. And Mr. Mklong don't say it's a choice, says it's her prerogative. Let's zoom into this choice that she made. The choice she made is not to open a criminal case. That is a choice that we hear. It's not in the affidavit, but we hear that it's her choice. The applicant is kidnapped by accused 5. She says she resisted, she was overpowered, and the like. In other words, accused 5, in her own words, if we have to agree this, accused 5 take her away from her children, 2 children, denying her with that action the parental responsibility that she says she has over the 2 children. He takes her away from a medical practice clinic because she could not be able to practice while she was kidnapped. But He's taken her away from, he takes her away from that as a medical doctor. He takes her away from her siblings. Because in her affidavit she says she still have parents and she still have siblings. And now she finds herself arrested now and applying for bail as a result of the actions of accused number 5. And Your Worship, you choose not to open a criminal case against this person. Now we hear that certain offenses they don't prescribe. She can still open case anytime in future. But so far, this is what accused 5 did to her. And she does not open a case. And the investigating officer says, despite the reservations that we now have with the picture that is attached, she has been coming to this court smiling with the same person that he says in her affidavit kidnapped her. I wish to concede, Your Worship, at this stage and correct one aspect. I'm not changing the affidavit of the investigating officer, but as a state, I wish to concede that what he says in the affidavit that there is no extradition treaty with Tanzania is not correct. Will that be used against him? I'm not sure, but it has not been addressed so far. But nonetheless, whether that treaty exists or not is neither here nor there. The application remains opposed. At paragraph 7.3, the applicant provides this court with family background. Amongst others, she states she has full parental responsibility and specific parental responsibilities and rights of her 2 minor children. These are the children that she left behind when she was kidnapped, and she opted not to open a criminal case against this person. And let's take it further, Your Worship. In her own affidavit, she's telling this court, I am challenging, amongst others, my transportation from Tanzania to South Africa. I'm challenging that in the High Court. Now, let's pause a little bit, Your Worship. She has been taken unlawfully by forced into a car to Tanzania. I quite agree, and I agree with my learned friend, that this matter is still being taken up on further on SCA. But so far we have judgments that remains until SCA changes it. But the point I'm trying to make is, Your Worship, you are taken unlawfully to Tanzania. The South African authority, I don't know who they are, they bring you back to South Africa, amongst others, to be with your children and to practice and go on with your practice as a medical, and they bring you back to South Africa. And you go and challenge that. You challenge the fact that you were brought back to Tanzania, where you did not want to be. She did not want to be there. She was kidnapped, according to her own evidence. It's a right to challenge whatever action you see. But what does this mean? It means, allow me to remain in Tanzania. That's what it means. And we are told she has no desire whatsoever to leave South Africa and to evade trial. Let me address one aspect that relates to the personal circumstances that are before us. The applicant states that prior to her arrest, she was staying at a particular address, which is 22A 2nd Road, Hyde Park, Sandton. She was arrested on 7 April 2023. Prior to my arrest, Your Worship, I assume it must be prior to 7 April 2023 when she was arrested in Tanzania. Or let's accept for the purpose of this case, it was on the 13 April 2023 when she was arrested to face these charges. She says, prior to my arrest, that was my address. She does not provide the investigating officer with the address at the time of arrest. And now we hear, and we accept, it's in the investigating officer's affidavit, that she was staying in this address, and she left in March 2023, and the investigating officer, I don't want to decorate it, but says unceremoniously vacated the place where he was staying. It's crucial to say, at the time, she still provides the investigating officer with this address, well knowing she's no longer staying there, according to her own evidence. Otherwise, how would the investigating officer have known this address? And now here in court, she provides the court with an alternative address. She does not state in her affidavit if this same address that she will be staying, she also provided to the investigating officer at the time of arrest. She does not say so. Why not? And it's her choice, Your Worship, where she wants to stay. It's a choice. But having said, I have siblings, I have parents, why would you want to choose to stay with a friend and not siblings or parents? Now, at the time this address was given in court, the investigating officer, yes, verified, in no space of time, short, I think we adjourned for an hour, which Advocate Dlamini finds offensive that in short space of time he was able to gather what he has gathered. It simply says how advanced the South African police services are. But the investigating officer, this has not been challenged even in the address. The investigating officer says, I have established that this is the nationality of this person. he does not end up there. He says, one of the co-accused, accused number 9, is from the same country, the same as this person who she says she will stay with. The investigating officer does not make judgment on this aspect. No. All that he's saying is there in the affidavit. He says it is concerning the ties that she has with this particular country is concerning. He does not make judgment. And yet, he is accused of being xenophobic. What does xenophobia mean? It means a hatred or a dislike of a foreign national. Does the IO say here that he dislikes or hates them? No. All that he's saying is it's concerning that accused 9 has been a gardener and security officer, and now we are giving another person who comes from. That's all that he's saying. He's not passing judgment. It's there in the affidavit. And yet he is accused of being xenophobic. But of importance, Your Worship, of importance, the applicant provides this court with an alternative address, granted. The investigating officer states in his affidavit, which is not challenged, in fact, it is commended, said, so it means even after the rental, she was still staying there. That's what Advocate Dlamini specifically said. But the fact of the matter is, there is this previous address. This is the address where she will stay. What does that mean in terms of whether the applicant has a fixed address or not? The fact that he provides an alternative address simply says, as we speak, not tomorrow, not yesterday, as we speak, she has no fixed address. And the investigating officer is saying what? He's saying her relations with these particular nationalities is concerning. And yes, he did not provide a tracker or evidence, but he goes on to say even a Mercedes-Benz that she was rented in her name was found abandoned in that very same country that I do not want to mention. I might be accused of one or other thing, but I'm not mentioning it. But it's there in the affidavit of the investigating officer. So, Your Worship, all that I'm saying to the court up to so far is that the applicant has not satisfied the court in adducing evidence that it is in the interest of justice that she be admitted to bail. And that relates to section 60, subsection 4B, which incorrectly is being said that that's the only ground upon which the investigating officer is opposing bail. Joseph, moving forward, insofar as section 64D The investigating officer states in his affidavit, there is a likelihood that the applicant, if released on bail, will undermine and jeopardize the objective of the criminal justice system, including the bail system. And when one looks at the grounds, the factors that the court must consider, whether this has been satisfied or established, is the question whether the applicant provided false information, issues like that, which we find in the affidavit of the investigating officer. Factly, he says the fact that she provided me with this address, knowing she no longer stays there, she was misleading me. She provided me with false address. And he goes on further, Your Worship. Provides a list of false information that the applicant made not at the time of arrest, but previously when she approached the High Court in Pretoria. In terms of her own affidavit, although the name does not appear, she states that she is married with 2 children. And in the High Court, we know her to be married to Thabo Bester, which is accused number 5. And not only that, the investigating officer states that amongst others, she says, under oath, which was commissioned before a legal firm of attorneys, that Thabo Bester's mother is deceased. And the investigating officer says, I traced her mother, his mother, and Thabo Bester's mother is alive. And we went further to conduct DNA, which is positive that this is Thabo Bester's mother. If one can deceive the High Court, what more about this court? Can this court really trust and conclude that it is satisfied that the applicant will stand trial, having gone to a High Court, to claim a body, claiming that body belongs to someone who we know by now is alive, is accused number 5. He's alive. And the investigating officer not only stops there, she says the applicant has established that the applicant, when claiming this unidentified body, she said it was her father. Can that be true? We know accused number 2 in this matter is her father. And her father is alive. Why would you deceive? And that is the evidence that this investigating officer says we have. In relation to what? To fraud. She goes further than that. This is just trying to show the court that there are factors weighing against the release of the accused, the applicant on bail. According to the investigating officer, even the founding affidavit is there. That was submitted in the High Court in Pretoria. She claimed her father, which is accused too, negotiated lobola and that 60,000 rands was paid and therefore the customary marriage was complete in terms of her own affidavit in the High Court. Who is the father? Accused number 2 in this matter. That the investigating officer also says accompanied the applicant to claim one of the bodies. That's in his affidavit. She goes on to claim that Thabo Bester's uncle by the name of David Magagula is deceased. And the investigating officer says, I have established from one class Magagula that there has never been a David Magagula. Lordship, insofar as Section 64E, the investigating officer states in his affidavit the likelihood that the release of the applicant will disturb the public order or undermine the public peace or security. In this regard, we are told that this cannot be correct because her co-accused has been released by the High Court and there has not been any public outrage. But I wish to state, Your Worship, the conduct and involvement and the role played by the applicant as outlined by the investigating officer clearly shows she has no respect for the criminal justice system. She orchestrated the escape of a person convicted of serious offenses and who was locked up at the maximum security prison. It is a demonstration of a disregard for the courts and the law. Let's remember that Thabo Bester was sentenced by a court of law. Then someone went to claim that she is deceased and she wants to cremate her, when in fact Thabo Bester was alive. That is a person who has disregard to the processes that led to the conviction and sentencing of accused number 5. Joseph, the fact that her co-accused have been released, in releasing the court, considered specific personal circumstances and whatever, and the role and everything. It took everything into consideration. The circumstances, the role, and the personal circumstances of the applicant here are quite different from each one of those accused who have been released. Therefore, the court cannot just on that basis say, okay, your co-accused have been released, I therefore also release you. The court must still apply its mind and the court must make a determination whether evidence has been adduced to satisfy itself that this applicant, not the others that have been released, this applicant, it is in the interest of justice to release her on bail. So that comparison, we have not even been told what factors the court considered in releasing them. We are dealing with this evidence before us that relates to the applicant. Your Worship, my written argument, page 9, concludes by making reference to State versus Miselo 2002, 1 SACR 49 constitutional. See, where the court concluded that the release of applicant will disturb the order or undermine. In that instance, the charge was a mere possession of firearm and attempted murder. Your Worship, the court must take the holistic evidence before it. The investigating officer has mentioned in his 5 pages, which are said to be stories, how Thabo Bester, how the orchestration of the escape of Thabo Bester happened, and the fact that he was incarcerated at the maximum prison. And he says in this affidavit, the mastermind was the applicant. So those circumstances, Your Worship, are the reason enough to be saying, with this that is before me, with the fact that a sentenced person for life is released, and the applicant has a role in that, and she even went to Tanzania. None of the other co-accused, there is evidence that they were also kidnapped and taken to Tanzania. That's why I'm saying the considerations and the factors in this case are different from the other co-accused. None of them was there anything said, even when one looked at the judgment of the High Court, that they crossed illegally or unlawfully without passports to any of the countries. Therefore, it is my submission that the court cannot, solely on the basis that the co-accused have been released, therefore, the applicant must be released. Your Worship, the investigating officer, in his affidavit under oath, provide the court with reasons why he believes the bail conditions should not be considered. And he substantiates on that aspect. Your Worship, the very same investigating officer that is being attacked personally and said to be decorating his affidavit mentions a factor which I believe is favoring the applicant. He lists the businesses that the applicant appears as a director. He lists them. In other words, what this means is, he is saying to the worship, amongst others, consider that she has businesses, which therefore I would have expected the applicant to be saying, Your Worship, one of the reasons I asked the court to release me on bail, I need to go and take care of these businesses of mine. But Advocate Dlamini says, so what? And the state is showing the court that the businesses are at different addresses. Indeed. But one wonders, because we are told these are the basic personal circumstances. He's a medical doctor. One wonders, because that is not being challenged. If she has these businesses that she has interest in, that she appears as a director, Why would she not disclose them in her own affidavit? Why conceal that fact? What is the reason? Because, as I said, it should be a factor that works in her favor. But she conceals it, does not refer to it anywhere. Your Worship, insofar as my written address, it is my submission. The investigating officer, the prosecution, the state does not carry the burden of showing or proving to this court that the applicant is not entitled to bail. She must first show the court that this evidence before the court are good enough to admit me to bail. Your Worship, when one looks at the two affidavits, the evidence that is before you, I'm glad that Advocate Dlamini referred to the applicant's affidavit as a simple and straightforward affidavit. That is not what the law requires. It says, adduce evidence, not simple, adduce evidence that will satisfy the court that is in the interest of justice, that she be admitted to bail. On the other hand, the affidavit that is criticized is extensive. And nothing in that affidavit shows, like the impression that Advocate Dlamini gave, that the investigating officer harbors any hatred or whatsoever against the applicant. He simply gives the court what his investigations are, what the charges are, what evidence he has. For instance, he says, I have since established from the bank records of the applicant that she paid 85,000 rand. Now, to accuse number one, the defense is saying, in fact, let me start this way. The court should be mindful of the fact that we are dealing with one accused here, which is applicant number 5. And therefore, the affidavit of the investigating officer and the investigation and the background she gives us about the applicant relates to the applicant only. And therefore, it could not be expected that he goes to an extent even saying what the other accused did. We don't know what the other monies came from and whatever, and we cannot say it here. All that he did, he zoomed into what the applicant only did. There are other amounts. Your Worship, as I indicated, I will also ask the indulgence of the court. There has been so much that I noted from the addresses of the two learned friends, and I request that we adjourn so that I go through and don't waste time in addressing the court on what I have already addressed, just to identify those that I need to touch on. I don't know what time is it. I see the court personnel are happy that we did not break for lunch. They are happy, but can I ask that maybe for 30 minutes? 2:30? Then I think I'll take about 10-15 minutes and then I'll wrap up. 2:30, Your Worship? Is that okay? Is that okay?
That's in order, Your Worship, as the court pleases.
recall the matter?
Yes. You may.
Thank you. Also, fortunately, I'm done. There's just one or two aspects that I need to clarify in concluding my address. The first one relates to what has been referred to as the discrepancy between the charges, the number of counts, and what the investigating officer states in his evidence, in his affidavit. In this regard, Your Worship, unfortunately, it is not for the investigating officer to formulate or decide the charges, but the prosecution, so he cannot be faulted that he mentioned less counts than what we have before court. Second aspect relates to ID parade. We have been told that there has not been an ID parade held. There's no need for an ID parade. When one looks at the affidavit of the investigating officer, he mentioned that there are direct or eyewitnesses. The state don't need an ID parade to prove any of those charges. The third aspect is that relates to the passports. In his affidavit under oath, the investigating officer states that when the applicant was arrested, he was in possession of two other passports. All that we have from the defense is from an address that says we deny she was in possession of the passport, of the two passports. Nothing that contradicts what the investigating officer states under oath. Then the next aspect relates to the unidentified bodies. And I remember specifically Advocate Dlamini asking the court, where is evidence to prove this? I'm not sure. As I already indicated, the investigating officer states in his affidavit that he has direct evidence to prove the state's case. We don't need the body, the unidentified body for bail application to be exhibited here. So to ask where is evidence? Then the aspect that has been raised regarding the period or the length of time that the applicant has been in custody and the chances of the matter being finalized far in the future. Your Worship, in this respect, the applicant had a right to apply for bail from the moment she was arrested. That's what our Constitution states. That's what our Criminal Procedure Act states. And if not at the time of arrest, from the moment she appeared before this court, she had the right to apply for bail. The court record so far will show that she has in the past, up until recently, been reserving that right, and therefore the state cannot be faulted that she has been in custody for so long. She opted not to exercise that right. Then I need to clarify one last aspect where the defense is saying the state says she contacted her children once. This is not in the affidavit of Colonel Flyman. Colonel Flyman specifically says she contacted her husband once, not children. So I needed to just touch on those aspects. Then, Your Worship, that completes my address to you. As pleases.
Thank you. Any reply?
As the court pleases, Your Worship, indeed the defense would replicate on some of the factors emanating from the state's submissions. Your Worship, in as far as the first submission is concerned, I wouldn't want to overflog the horse, but I think it's important to drive this point quite succinctly, because this is a salient issue pertaining to the schedule of this offense. Yet my learned colleague's address on this point is to the effect that he's mentioning some doors, some back doors in terms of the evidence and being selective on how we quoted the count. Count 3 is quite clear. Either way we look at it, it's quite clear. It talks about furtherance of common purpose. That's the first leg of it. It then takes us to the second leg. And the second leg of furtherance of common purpose then deals with monies allegedly paid. Endeavors to locate an amount that informs the schedule to be elevated to Schedule 5 were in vain. Those endeavors were in vain. Nothing in count 3 suggests any amount other than 85,000 rands. No explanation is provided to this court of the omission thereto. No explanation whatsoever, other than the state desperately trying to fix a deficiency which I called an incurable deficiency in their own evidence. State furthermore refers to count 4. And state makes a concession but throws a caveat to that concession. State says, oh, well and good, count 4 makes reference to accused 1, 3, and 7. But wait a minute, you ought to have read the whole count holistically. Suppose that angle should have been applied. But that argument is defective. It's defective in the following manner. Which of the two different parts of this count would the court follow? Will the court follow that this charge, count 4, relates to 1, 3, and 4, and go further to decide, oh no, let's forget about 1, 3, and 7. This count 4 relates to those other accused, inclusive of accused number 4. On what basis are we calling you to make that determination? Legally so. We are bound by the evidence presented. The state is bound to, parties to proceedings are bound by papers before court. Now, it's inescapable that we will try to correct this. I wouldn't even want to call it an error. It is what it is, evidence. We can't correct it anyhow. It's here with us. So my submissions, Your Worship, is that perhaps if one was to use or steal from the word of my learned colleague, perhaps the door is on the other side. not with the defense. The state is frantically and in desperation trying to push this aspect so as to correct the schedule. And we know the importance of the schedule. And the state is fully aware of the importance of the schedules. Therefore, the state should have been meticulous in ensuring that it places all the allegations pertaining to the count in relation to the applicant. But the state put the point further to say the defense is making a lot of issues around the fact that we didn't place all other counts. Perhaps the state didn't comprehend the argument. The contention has always been that, yes, according to the charge sheet, there are 16 counts at least. But according to this evidence, the evidence says something different. That's what we are saying in relation to the applicant. Count number 14, which the state mentioned as being a count that also deals with corruption in relation to accused number 1 being offered an amount of 105,000. Where is it in the affidavit? Where is it in the evidence? In the absence of that being part of evidence, our argument is the charges in that form, in their current form, do not talk to the evidence. And that's the end of it. And that settles the debate in respect of the schedule of the offense which the accused or the applicant should face. The state bears that on us. And it's our submission that the court should find accordingly. Now, Your Worship, moving on to the next aspect of the state submission. And this now relates to the reliance on Section 64B, particularly attacking the version of the applicant. I see in the state's address, the state is saying, unfortunately, both parties didn't have the benefit to cross-examine and test the veracity of the allegations contained in both affidavits. Perhaps to even correct it a bit, because part of it is correct in that the defense has been denied that benefit, that opportunity to test the veracity of all these allegations. So is the state. But the state had a second bite by responding in their affidavit and making reference to some of the issues pertaining to the allegations by the applicant. Now, a crucial question arises here, Your Worship, in that with the state having the second bite, did the state make an effort to undermine the version that the applicant is bringing to this honorable court? The version, to the extent that I did not leave the country on my own volition. I did so involuntarily. Other than to, as I indicated, to insinuate and cast aspersions in terms of the conduct and what could a reasonable person in the circumstances would have done. But we are mindful, Your Worship, of the fact that the applicant has a right, constitutionally protected one, which is quite sacrosanct, a right to remain silent. One can also not ignore the right to be presumed innocent until proven guilty within the context of bail application. So what we have here before this court are two versions which largely have not been tested through cross-examination. now for the state to get into the space of trying to assert their version to being better than the applicant's version, because I wouldn't even say probable. It has not been tested. Which takes us to the very same assertions that the defense put across in respect of the character of bail, which I quoted State versus Filjun to say the principle adopted in that matter was to the effect that we are here in court dealing with a particular proceeding which is sui generis. It's inquisitorial in nature, but has got nothing to do with the determination of guilt or otherwise of the applicant. Nothing. This should not be deemed and seen to be a dress rehearsal of a full-blown criminal trial. Some of the factors, if not all of the factors that are there, which the state comes to this court and make and contend that they were not disputed. They were not disputed. Neither were they rebutted through evidence, through cross-examination. Now, it takes us to the level of the probative value. What is required of us? What this honorable court is impelled to do, which is to attach a particular weight, and legislature is deliberate on this, because we're sitting with an untested evidence. Uncontested, how else would she have contested it? Your Worship, it is my submission, therefore, that we are of the view that the state, in as far as aligning, because my learned colleague aligned with the defense in as far as the legal position, the correct legal position is concerned, which is that this proceeding is not to determine the guilt of the accused. But at the same time, on the same breath, the state produces a whole range of arguments around the guilt of the, or rather the strength of their case, and all of that. It is our submission, Your Worship, that those arguments, in as far as bail proceedings are concerned, they do not sufficiently cover and satisfy the requirement as enunciated in the provisions of Section 60, subsection 4, A2A. There is reference by the applicant to the fact that other accused were admitted to bail. We need not be selective in terms of how we present arguments. The manner in which we present arguments shouldn't be such that it causes unnecessary confusion by misconstruing the points that we brought forward. The point here was not to come with a comparison of any nature, but to say this fact of the strength of the state's case is the very same fact which the state used to oppose the bail for those who successfully appealed the decision of the court accord. So we are saying that is the basis of us bringing this fact into the space, because this fact, Your Worship, deals with section 60, subsection 6, F, A, G, and H. F, the nature and gravity of the charge on which the accused is to be tried. The nature of the charge is the same. With almost all the co-accused. in this matter. G, the strength of the state's case. That's what they were saying against the three accused. They relied on the very same evidence that they want to use against the applicant is the same evidence they have against the other accused. We cannot identify any distinguishable facts around this issue. They are same in character, and the court should treat them as such. State also makes reference of reliance in terms of section 64E. Section 64E, the state used the very same reasons with regards to the other co-accused. And the state is seized with the ruling of the High Court in that respect. It's inescapable, Your Worship, that there is no evidence of public outrage. When we address the court based on evidence presented to court. What the state is addressing from the bar is not evidence. The state is making submissions that are not backed up by facts. It is our submissions, therefore, Your Worship, that looking into the provisions of the sections alluded to, section 64A to E, none of those likelihoods as outlined have been established by the state. And Your Worship, we should also be careful not to have a situation of creating an animal farm situation where some accused will be treated differently but facing same charges. Accused number 2, for that matter, his bail was not opposed. There are also other accused who came later whose bail was not opposed. Now, the distinguishing feature which the state relies on heavily is that none of them left the country illegally. And this takes me to the next point. Reason has been advanced by the accused, by the applicant, in respect of circumstances that prevailed, that led to her leaving. This court is not called on to really make a determination of whether is this really plausible, is it viable. This is what the applicant is saying. And the applicant is saying, notwithstanding the fact that I have a right to remain silent, I wish to inform the court how I exited the country. Now, the state seems to be having qualms with this explanation. The state seems to expect the applicant to say more. What more? They are also asking rhetorics. How, when, who. Those are rhetorics. And we are saying we are mindful of the fact that we have the right to remain silent. We will, at an appropriate time and forum, deal with this issue. But for purposes of this bail, I did not leave voluntarily. But I will take the point further, which was also eloquently articulated by my learned colleague, Advocate Dlamini, to the effect that he read out the warrant of arrest. The date there is quite very important, because there are no allegations to the effect that the applicant left to evade anything. There's nothing. In actual fact, the only time you find and locate evasion in the affidavit of the state is where they are saying for 11 months she evaded justice. Even to this date, the state had the opportunity to address it. Much as the state is critical about certain points, which I will address, which were left not addressed. This point of the state, the applicant evading justice for 11 months, it's unsubstantiated, even to this date.
If I may get clarity, I'm not disturbing. Are we still replicating? Because now it would appear that my learned friend is repeating their submissions. And the state never made any submission regarding warrant of arrest and 11 months, not in my address. So what he is replicating, we should be careful not to repeat our arguments that are already in court here. Unless, I'm not disturbing here, you can continue, but I just wanted to make sure I'm in the right court.
Not in the right court, in the right proceedings. Your Worship, in reply, indeed I'm replicating. Now, when you replicate, you deal with those aspects that you didn't deal with, but the interconnectedness of the facts calls for one to piggyback and point out where to locate certain aspects that we are basing our argument on. For instance, just to assist my learned colleague, we are addressing the issue of applicant having left the country, having not explained herself as to why she left, how, and all of that. And we are saying these are the facts, and inevitably one would have to refer this court to avoid a situation where the court gets to be confused as to the direction we are taking, to say, Your Worship, this point is backed up by that particular point. So in that way, with due respect to my learned colleague, that's replication, and I know how to replicate. All that I'm trying to do is to give context to the issues that I'm replicating to.
And I accept that.
As the court pleases. I remember during my early stages as a legal practitioner, that was the tactic that we used to employ to disrupt the chain of thought. So apologies, Your Worship. I was a bit distracted, but I'll gather my thoughts and proceed accordingly.
So are you saying it worked a little bit?
Okay, Your Worship. Your Worship, touching on the issue of flight risk. If we're saying to this court there was no warrant of arrest, which becomes a sore point to a large extent, there was none. There was no reason why for the applicant to leave. And if there was no reason for the applicant to leave, there is no reason to doubt her evidence in as far as the manner in which she left the country. The state again reintroduced a point around the nationality of the person who's going to reside with the applicant. And the state creates a certain nexus, which is highly problematic. It says, look at the nationality. Something is wrong here. I smell a fish. Can the state really get to that level? Can we get to a court of law and speculate that there are similarities here? By the way, Section 9 of the Constitution is quite very clear. It's an equality provision. All are equal before the law. Is this not discriminatory? That the state is now diverting the attention. The issue here, Your Worship, is the alternative address. And the person that is amenable to accommodate the applicant is actually, and this is what my learned colleague Advocate Dlamini indicated, a medical practitioner under the employ of this South African government, who, by the way, the state, through the state, is now a permanent citizen, she holds a permanent residence. She's a permanent resident. But the state keeps on going back, tracing her roots. For what purpose? The state should be saying she is not staying there. If in the absence of any argument to the contrary, I submit with respect, Your Worship, that this evidence of the applicant should be accepted. There's no reason to do anyhow. Your Worship, by the way, the state seems to suggest that for one to be a correct candidate to be admitted to bail, you need to have a fixed address. Unless I would not have located the rationale behind introducing this point. But our law is settled in that regard. Otherwise, people with no address, street kids, would not be eligible to be admitted to bail. And that will be discriminatory, and that would be unconstitutional. Where we are, what we say is that there is a confirmatory affidavit, and that confirmatory affidavit, by the way, annexed a very important instrument there. The utility bill from ESCOM, which the state tries to bring some comparison with regards, as if, Your Worship, the state suggests 2 wrongs makes a right. We did not comply with the issues pertaining to some of the evidence which I'll deal with now, and you also didn't. So let's just dust off and move on. That's not as easy as that. The reliance of the state in respect of the downloaded photographs are concerned. The law is settled. The Electronic Communications and Transaction Act, ACTA, is quite clear. And ACTA deals with data, admissibility of evidence that is produced in that form. And if the state had an issue with that, with the defense using the utility bill that is a copy, the state, by the way, the machinery that they have now, it indicated that it shows the efficiency of machinery. They could have authenticated it, but was that necessary? There is an affidavit, and that was the end of the issue regarding the applicant having to get an alternative address. Your Worship, the Section 66A leg of it refers to, and it says, in considering whether the ground in subsection 4B has been established, the court may, where applicable, take into account the following factors, namely the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried. There's no mentioning there. The state is saying she has siblings, she has parents. Why is she not staying with the parents? To the extent that the applicant says, I have an alternative address. That should be the end of the inquiry. Nothing more. As to who she would be staying with, it's really, I don't want to say neither here nor there. I will say it is immaterial. Your Worship, I wouldn't want to get to the space of personal attacks, this and that, but I struggle to locate personal attack on the affidavit of Colonel Flyman. I tried in vain to locate. And it would seem that Colonel Flyman's affidavit is really captured in a manner that is so respectful and all of that. But my learned colleague pointed out a very offensive word that is used, eloped. And no one is saying anything about it. The state is not saying, no, but yes, I see the Colonel Flyman here meant to say this and that. So I would submit, Your Worship, that in as far as Colonel Flyman's evidence is concerned, particularly around whether the applicant left voluntarily or not, it's not addressed. Whether or not when she came here, she should have told Colonel Flyman that no, she will not be staying there. She wouldn't have known where she will be staying anyway. She was going. She was under arrest, and she is not saying she gave me another address. She gave that 22A address, and that's the end of the inquiry. Your Worship, I am inclined to deal with Section 28 of the Constitution, because it's a point that was sharply raised by my learned colleague for the state. Now, it is common cause that the applicant is a primary caregiver. This aspect is not disputed. All that the state is doing is to cast aspersions on it. If you are a primary caregiver, why did you leave the country? Now, Your Worship, I will refer the court to the probative value of an applicant who comes before court and indicates that I'm a primary caregiver, and how the courts deal with this. She has 2 minor daughters. I thus contend that this court is enjoined to consider the interest of her children, particularly with reference to Section 28(1)(b) of the Constitution. And this refers to the right of a child to parental care. And this should also be read with Section 28(2) of the Constitution. In other matters, this point alone was considered to constitute exceptional circumstance. And we know that exceptional circumstance in proceedings of this nature calls for a higher test. But this current fact was accepted to form part, to be to constitute exceptional circumstance. So, Your Worship, I hope I've dealt with expansively with the assertion that the state, or rather the defense, didn't challenge the veracity of evidence and allegations contained in the affidavit. I've dealt with that. The fact that I say during the proceedings in future, I intend to plead not guilty. I'm challenging this. I'm actually putting the state to the proof thereof. Is that not sufficient for purposes of this? I think I submit it is sufficient, Your Worship. Your Worship, it will be remiss of me not to deal with State versus Dlamini, yes? When dealing with this, Your Worship, this point, I'll submit that it is wrong to subordinate the constitutional standard of interest of justice to the provisions of the statute. The statute must be interpreted in light of the Constitution. When that exercise is properly conducted, one must bear in mind that the interest of justice dictates that the purpose of bail provisions is to ensure that the attendance of an accused in his or her trial is not compromised, and that an investigation into the alleged crime is not hindered. This touches on section 64B as well as C. Now, with reference to State versus Dlamini, the Constitutional Court held in paragraphs 4, Your Worship, paragraphs B, C, and D, and this was in contradistinction to paragraphs A, that you need to be directed at protecting and promoting the integrity of the investigation and presentation of the case in respect of which the detainee has been arrested. Those are undoubtedly the primary and most commonly expressed objective of the pre-trial detention. Just to preserve, to ensure that whatever I want to use against the applicant, against an accused person, has been preserved. It has not been hindered. My investigations are going to be are such that they are not interrupted, interfered with in any way. That is the barometer that is to be used. The interest of justice in regard to the granting or refusal of bail. Therefore, they just focus primarily on securing the attendance of the accused at trial and in preventing the accused from interfering with proper investigations and prosecution of the case. Your Worship, that's succinctly what legislature requires of us in proceedings of this nature. Nothing more. I submit, therefore, Your Worship, that the applicant, should this court find that the schedule under which she's charged falls under Schedule 5, that she is discharged, the onus bestowed on her on the scale of balance of probabilities that the interest of justice permit the release of the applicant on bail. Your Worship, that will be my address in as far as replication is concerned. May I just check with my colleague quickly? As a court pleases Your Worship, my learned colleague has just pointed out some of the facts which were omitted in my address. With your leave, may I just address this and finish off and conclude. Your Worship, the state mentioned an issue around their bona fides in terms of how they couched their evidence and on that affidavit, that some of these factors were favorable. She's married, a married woman, that's a favorable point. But who eloped? Contradiction. But at the same time, the state alleges that we favorably put in the issue around the applicant having businesses or being a director. We did so to try and show that if she is to get out or be admitted to bail, she has economic interest. This is my learned colleague testifying from the bar. It's not in the affidavit. In the affidavit, all we know is these are the companies. They are taking it further. These are the addresses of the companies. It left the defense to even speculate in terms of what could be the relevance of this. We submit that was superfluous for the state to even put those factors. But we also submit that those factors were actually placed there to try and show different addresses. Now that the defense attacked those modalities, state changes and introduces something that is not part of their evidence. Your Worship, I've dealt with the issue around whether of the timing in respect of, and the choice, by the way, in respect of the applicant to lay charges or not. And in my submission, I say, Your Worship, with respect, that that choice of the accused to or not to open charges, that choice cannot evaporate at some point and tender the applicant not to be legally allowed if she was to make that choice. But can that act or omission be then used to call on you to draw an inference on such a conduct? And can that suggest that applicant in any way could not have been coerced? There's no basis in law. Even on their facts, there is no basis to suggest that. So I submit, Your Worship, that this assertion by the state is misplaced. But in closing, there is a contention that is so patently misdirected, dealing with the pending litigation where the applicant challenged the lawfulness of her disguised extradition. This is not the proper forum to discuss it, or rather to debate this point, Your Worship. But since it emanates from my learned colleague's submission, I'm inclined to give a perspective. The argument that the applicant's posture to attack or to challenge her unlawful arrest, which she called that she was abducted and kidnapped, blindfolded, whisked away into an airport. It is so legally flawed to even suggest that she's challenging that arrest for her to be returned to Tanzania. Where does the state find this assertion from? It's not in the papers of the applicant here. It's not in the papers of the applicant in the pending litigation. All the applicant is saying, the prayers she's looking for is the proceedings to be declared a nullity. Nowhere has the applicant ever made any request or demanded to be taken back to Tanzania. That argument is legally flawed. That's my submission, Your Worship. And to this end, it seeks to suggest that if she is to be released, she will go to Tanzania. For what purpose? In actual fact, Your Worship, the state makes allegations about certain affidavits which suggest that the applicant is dishonest, she lied under oath. In all these charges, unless I miss something, I don't know if there is a perjury charge there. But that being the case, she has not been convicted of that. The state is calling the court to take judicial notice of a fact that is still to be decided. The fact that the applicant says, I'm going to plead not guilty and I'm not disclosing the basis of our defense, does not give the state a free, I nearly say free right, but just the latitude to make allegations that this is a case that has, or rather that the applicant has been convicted of fraud, that she lied under oath. That is part of evidence that is going to be presented before this honorable court. I think I've touched on the fact that the applicant has assets in any event worth 1 million. Yes, I think we've dealt with the other aspects, Your Worship, particularly with reference to the fact that the flawed argument around whether the accused, the applicant, stayed in that address that she mentioned to the investigating officer legally or not. Advocate Dlamini dealt with that. The fact that the investigating officer confirmed that in his affidavit that at some point in March, he has information that the accused stayed at that address, and such occupation of those premises went beyond even the period that he mentioned in the affidavit to have been a period which meant the affliction of the lease agreement. Beyond that, one cannot even claim that it's tried law that lease agreement, unless it's so prescribed by law to be reduced into writing. There's so many lease agreements that run on month-to-month basis, whatever the case might be. But that argument is also legally flawed. Your Worship, this brings me to the end of my submissions, unless the court has some other aspects emanating from my address. I'm at your disposal, Your Worship, to address it. I know, Your Worship, I keep on saying final, last. It would seem that my address is semi-final, quarter-final, but this time around, my learned colleague, and I've indicated to my learned colleagues that this is now final. The issue on bail conditions, section 60, subsection 12. I think I addressed that issue. It will cure any concerns that the state will have in respect of aspects of section 60, subsection 4b, that there is a likelihood that if the accused was to be admitted to bail, will attempt to evade his or her trial. That brings me now, Your Worship, to the end of my replication, as the court pleases.
Thank you.
Thank you, Worship. 20-4. I want to believe that the issue of the next date has already been canvassed in chambers, and we are agreeable that for judgment purposes that the matter be remanded until the 11th of September, next week, Monday, 9 o'clock. She remains in custody until otherwise pronounced by the court. Thank you.
The court pleases, Your Worship. When I agreed to Monday, I didn't know that it's the 11th of September. But that being the case.
Is it your birthday?
11th of September.
Is it your birthday?
No, it's the 11th of September. Yes, but that being the case, Your Worship, the arrangement is suitable. The date thus is confirmed, as the court pleases.
Thank you. The matter is postponed to the 11th. It will be for judgment in custody until then. Thank you. You may stand down.
That then concludes our role for the day.